Hi, thanks for joining me. In this lecture, I want to make what I am sure is going to be a relatively controversial argument. I'm going to make the argument that when thinking about the US Constitution, it's probably best to think of it as being two separate regimes, even though we technically, or at least theoretically, have only had one constitutional document. Now, why two? Well, sure, there's only been one document that was ratified in 1789. But in reality, when trying to understand how our Constitution works and the relationships between the states and the national government, or the people in the national government, you need to understand that there have been two clear periods in American history with a transition between them. And in each of these two periods, the Constitution was responsible for doing different things, and the United States government that was created by it had different sets of responsibilities. In a sense, it means that our Constitution had two different concepts of government. Now, in order to explain why, I first want to talk a little bit about what a constitution is, or why we need constitutions to begin with. Now, in a previous lecture, if you watched the video, you may remember that I mentioned that democracy essentially exists or consists of four different characteristics. Now, one of those four characteristics is what I call the rule of law, and simply meaning that it's important for regimes not to allow behaviors that would destroy the regime itself. For that reason, all regimes, all governments need to have some guardrails, if you will, some protections in place that make sure that the individuals who are running the government have some controls or restrictions placed upon them. Now, in the American democracy, the reason why we need to do this is because in a political system based upon popular will, it becomes very possible for the popular will, for the population, for the people who win elections, to use their power of government to essentially destroy liberty or erode equality for the losers in an election, particularly if the winners and the losers become fixed or stratified over time. Another problem that often comes up with government is that we become uncertain about the future if we're worried about the fickle nature of public opinion, or the fickle nature of who's going to win elections in a democracy. So for both of these reasons, it's important to create what John Adams calls a government of laws, not a government of men. That is to say that while men and women, while individuals in our society may be responsible for creating the laws, it is ultimately the law that we're answerable to, and not to the individual politicians who are making the law at any given moment. Now, as part of this creation of governments of laws and not men, constitutions do some other things. For example, they create the rules of governance. They decide who in government gets to make what decisions, or what kinds of decisions are allowed to be made. They also create and establish the powers and the responsibilities of both the government and also, in many cases, the citizens. So the government can do certain things, but the government also has certain responsibility to their citizens. And sometimes in constitutions, we'll find spelled out what citizens must do as well, such as pay taxes or participate in the military, if so stated. The Constitution does one final really important thing. It creates the non-violent rules for change. Now, this could be change in terms of just simply changing who's in charge of the government through elections, but it also creates rules for changing the regime. In some instances, this might mean amending the Constitution, and in other instances, it may involve using existing amendments or existing clauses in the Constitution to invoke some kind of new change that becomes necessary. So, in the United States, in our history, what was the first regime? Well, the best way to understand the first regime is to think about the US Constitution as ratified in about 1789, and as amended soon thereafter through the addition of the first 10 amendments of the Constitution, commonly known as the Bill of Rights. Now, this document, the original regime of the US Constitution, was created as a result of a series of negotiations between representatives of the 13 states. They had originally had an Articles of Confederation, but they realized the Articles was too weak, didn't have nearly enough power, and couldn't do the job well enough. So the 13 states send representatives who then try to form a new government that's going to be stronger than the original, that's going to become more centralized than the original. But, and this is really important, among the chief functions of this new constitution is to both protect the existing states and also make sure that the existing states are empowered, both in terms of their ability to control the new government, but also in terms of their ability to maintain control over many of the powers they used to have before. So what are some of the examples of how this empowerment might have worked? Well, for one thing, we created a federation under the new Constitution, as opposed to what could have been a unitary political system after the Confederation under the Articles had been abandoned. We also created within the Constitution a more powerful branch of a bicameral legislature, the more powerful house of the bicameral legislature, which we call the Senate. Now, in the Senate, unlike the House, the principle of state equality was maintained. Every state, regardless of its size or regardless of its population, gets the same number of votes in the Senate. And the Senate is also given some cool special powers that make it, in many respects, what we consider the upper chamber of Congress. It's the guardian of federal power, for example. The Senate, without the assistance of the House of Representatives, mind you, is responsible for making or for confirming all of the appointments made by the president. The Senate's appointment power includes appointing all the judges that are ultimately going to be overseeing the meaning of the law and the meaning of the Constitution. The Senate also solely has the ability to approve treaties that are negotiated by the president, which, according to the U.S. Constitution, has the effect of law. So effectively, without consulting the House of Representatives, the president can negotiate a treaty and then have that treaty ratified by the Senate that makes the government and its responsibilities binding as part of the federal powers. Something that we also often forget is that under the original direction of the U.S. Constitution, these senators were appointed by the states through a process determined by the states, as opposed to being directly elected by the citizens. In fact, the only individuals directly elected by the citizens under the original language of the Constitution would be the members of the House of Representatives. And we still don't directly elect the president. The president's elected by the Electoral College. And in that Electoral College, we have to understand that the states, specifically small states, are given disproportionate power relative to their population to make sure that smaller states are able to have greater amounts of control, not only in the Senate, but also in picking who the president is going to be. Now, the state dominance doesn't just simply exist in how the government is supposed to be formed or who gets elected to it. The state dominance also includes certain aspects of governance itself. If you read the Constitution, the First Amendment of the Constitution begins with the words, "Congress shall make no law." That was intentional. While Congress shall make no law abridging the freedom of speech or press or religion or assembly, the states were allowed to do so. In fact, states could, if they wanted to, establish a national church or favor religious organizations under the original regime, under the original conceptualization of the United States Constitution. And perhaps most famously, states could have, if they wanted, they could have slavery as a system of labor within their borders. Clearly not something that is allowed today, but certainly was allowed under the original Constitution if the states so chose. And then another one of the amendments, the 10th Amendment, basically says that anything we forgot in the U.S. Constitution, any powers not given to the national government in the U.S. Constitution, remain with the states or the people. So again, the states are given dominance. So that's the first regime. What about the second regime? But the most important key to understanding the second regime of the United States Constitution is to understand some key language in the 14th Amendment of the U.S. Constitution. The 14th Amendment was one of 3 amendments ratified in the immediate aftermath of the United States Civil War. The 14th Amendment, first of all, and for the first time, establishes a constitutional understanding of what it means to be a citizen. A citizen is anybody who is born or naturalized in the United States and under the jurisdiction thereof, which we assume means typically these are not representatives of foreign countries who are not answerable to our laws under the Constitution. And in addition to creating this idea of citizenship, the 14th Amendment also says that any of the privileges or immunities, any of the rights that are guaranteed to citizens under the national government's constitution must also be observed under the state constitutions. In other words, not only can Congress not pass a law creating a religion or abridging freedom, now under the 14th Amendment, the states are not allowed to do so either. And this is the fundamental characteristic of the second regime. The second regime empowers the national government to determine what citizenship means, what the rights of citizens are, and to protect those rights from the states. Now, the 14th Amendment may be the most important, but it's not the only amendment that we need to consider when we're talking about the construction of the second regime of the U.S. Constitution. The 13th Amendment ended slavery, taking away the ability of the states to determine whether or not people could be owned by other people. The 15th and the 19th Amendments further defined suffrage to make sure that anyone could vote once they reached the adult age of 21, whether they were African American or regardless of their color, regardless of their national origin, or regardless of their gender. The 16th Amendment allows the national government to impose an income tax directly on citizens. Prior to that, there could be no direct taxation of individual citizens. And along with the income tax comes significant financial resources. And then, of course, the elimination of the indirect selection of the Senate by requiring the people to vote on the Senate with the 17th Amendment in 1913. So from this period of about 1865 to this period of about 1920, you see all of these amendments to the Constitution that are all geared essentially to establish the rights of citizens, to guarantee that the states had to observe those rights, and then to empower the national government with the resources necessary to protect those rights. At the end of the day, what does this mean? Well, it means that the national government, if it chooses to, is now in a position to not simply be a contract of the states and by the states and for the states, but to actually become a contract of the people, by the people, and for the people. The US government can actually functionally get involved in protecting citizenship rights, and it has the resources necessary to do that. So here's a couple of things I want you to think about. First of all, I want you to consider, how would the United States today be different if the United States government, the national government, had never been given the power to enforce equality of citizenship? What would it mean, for example, if we never had a civil rights movement or a civil rights revolution, if we never had the Civil Rights Acts or the Voting Acts, if we never had the changes in law that ensured that women had to be treated equally to men? None of those would have been possible if it had not been for the creation of the second regime and the amendments that caused it. Also, think about, how would America be different if you were not allowed to directly assess taxes on individuals? Because it is, after all, the income tax that we use to pay for most of the government we enjoy today, including direct taxation in the form of payroll taxes that pay for our key entitlement programs like Social Security and Medicare. So thank you for watching this video. I hope you enjoyed it, and I hope that you got something out of it. Please, if you're interested, go ahead and check out some of the other videos that have been produced in the series, or check out some of the other topics that we have discussed as well. Thank you very much.